I just listened to a audio recording of Ted Cruz giving his oral argument before the Supreme Court of the United States in a case concerning the death penalty for child rape. First, I'm going to say I've never listened to any of Ted Cruz's opinions or read through any of Ted Cruz's opinions. My contention to this day has been that I contacted Ted Cruz as a member of the Senate, and it is not prudent, I believe, insofar as he has failed to act as a member of the Senate in regards to his role as my representative, to attempt to go through the catalog of his past for any specific reason. However, the context under which I'm listening to this is in consideration of an article I'm reading that was posted on the Federal Reserve site concerning executive compensation and concepts of relativism or relativity in terms of understanding risk taking. Why would I do that? Because my understanding for some time is that someone at some point allowed my life and elements of my life and political capital to be made available to Ted Cruz personally for his political gain. And B, that part of what I was experiencing when I was trying to compile my own legal argument were understandings that both Cruz and Abbott had opinions, had authored opinions or arguments in cases in Texas that could have supported my case, but I understood there was a conflict of interest in trying to use their cases. So I have refused to this day to read any of the opinions or arguments concerning cases that were done by Cruz or Abbott when they were in either the Attorney General or the Solicitor General position. And I've only done John Cornyn a few times for intelligence-related reasons. Ted Cruz is not on the Intelligence Committee, so it's a different situation and consideration, and considering the actual very personal elements of my life that have been commingled with his, it's another matter altogether. It seems that that opinion was given on April 16th of 2008. Not so ironically, as I've pointed out, the theft of my pension benefits and retirement benefits in conjunction with the tax I was already charged and for which I did not receive a return is twice the amount of 416. I just realized this 2 days ago. As of today, and having heard his argument, I'm going to say just the things that come to my head off the top, or the things that were my first inclination for response. During that time frame, I was an executive. I was I was a co-director of a nonprofit organization attempting to assist girls that were in the sex trade. Some of these were minor girls as young as 14. Apparently 14 is not young enough to qualify in consideration of the specific case that Ted Cruz was discussing, but many of these girls had experienced sexual violence below the age of 14. And the situation in my life and how I responded and what I did was impacted accordingly. Secondly, one of the things he discusses his case, the only actual case he cites is one that he identifies as coker. I am just going to acknowledge that coker is also a term that is used in industries that Ted Cruz has very vested interest in. I mention this because it's important. It's important that when he was speaking before the Supreme Court of the United States, the only two cases he names are Coker and Blackstone. I'm sure we all understand and know that when you have the option or the possibility of speaking before a Supreme Court in such a manner, that it can also be a kind of economic event, and not just economic in terms of monetary, but economic in terms of what it is the United States and the people of the United States have to work with in order to protect ourselves and in order to fortify ourselves as necessary. So when you're speaking before the Supreme Court and those are what you offer as part of your argument, that needs to be considered accordingly as well. Now, one of the things that was noticed, that was mentioned here, two matters that were discussed, had to do with a request that was made after one of the questions was asked of him concerning what would constitute a particular kind of offense. One thing that was not said was the concept of elements related to habituation to patterns of behavior, how the response that the society provides sets the terms in so far as those who would seek to pursue crime understand that there are consequences, and the enforcement of the consequences is part of what goes into considerations of social response to toleration of those kinds of crimes. So even if one were to address it or pursue it from the perspective that Cruz did, discussing how different states would be implementing it according to their state law in a manner that he identified as being what he expected and would accept in terms of the constitutional interpretation, then how one state, especially in regards to a consideration that the same kind of element or the same kind of statute had been applied in multiple states, responds, especially when in consideration of the severity of the crime, is going to be a reinforcement to other states. There's plenty of precedent on that, especially in consideration of the states that were mentioned, and concerning their manners of response to local issues relative to each other. So the other thing that brings up is something he had said about lacked the culpability. And so the question means, well, in what manner did they lack the culpability? Does this speak to state of mind? And so if we are discussing matters in perspective of state of mind, that also has to do with cognizability, with understanding that what you're doing is a crime and whether or not you made a conscious decision to engage it as a crime to begin with. Now, there is another case that went before the Supreme Court that is very relevant insofar specifically as it was the state of Texas that brought the case before the Supreme Court, where in the dissenting opinion, Justice Scalia discusses this practice or this praxis of engaging in commission of a crime in order to basically risk having it presented before the court in consideration of a determination of how that constitutes a crime, what the penalty would be, and whether or not engaging in it in that manner would actually create a manner of culpability. I consider and understand these are two completely different paradigms. That if one is either unaware of or not cognizant of the commission of a crime, speaking of state of mind in that regard is very different than one who is taking a calculated risk to engage the crime in order to chance that they will be able to establish some precedent that will allow them to escape any sort of penalty. And for that reason, it is even more important to consider something as substantial as the kind of case that was being presented from another perspective. With only 8 to 10 minutes of presentation on that case and without reading anything, my question is, was the right approach pursued? The concept of discussing it from an extremely or exceptionally egregious crime and then trying to go back all the way to Saxon law seems to be insufficient. The understanding of trying to parse out specific ages also would have to have been predicated upon some sort of standard that would determine the difference between a kind of sexual assault involving a child of one age versus another. That has nothing to do with apparently the capacity for that child to consent to the sex act to begin with. And that would be where I would start.